Yes, he was arrested and obviously uh, on the evening and got out the next day. The plea is for time served.
Yes, but where was he? Where did he get arrested, or where is his time, his back time? Because it's not on my system, meaning it's probably in a suburban jail.
Okay, what was the local agency that you got arrested? It was Mesquite.
Okay. All right, we'll get started then. We're on the record in cause number M1741114, the state of Texas versus Dillard Smith. My name is Judge Julia Hayes, and I preside over County Criminal Court number 2. Mr. Smith, which is where your case has been assigned. The purpose of this hearing is for the defendant to enter an agreed plea. Therefore, the state of Texas has waived its appearance. Mr. Smith, will you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And are you Dillard Smith?
Yes, ma'am.
And what is your date of birth?
1/29/1967.
Okay. Did you agree that we do your plea over Zoom video conference?
Yes, ma'am.
You can put your hand down.
Okay.
For the record, the court's court reporter is with us, defense attorney Mr. Johnny Guscio, as well as the court, all of whom are appearing over Zoom. Mr. Smith, do you understand what you're charged with today?
Yes, ma'am.
Do you understand the range of punishment?
Yes, ma'am.
Have you discussed your rights with your lawyer?
Yes, ma'am.
Do you want to have a trial?
I waive the right.
Okay, so you do not want to have a trial.
No, ma'am.
Are you a United States citizen?
Yes, ma'am.
Counsel, do you believe your client is mentally competent?
I do, Your Honor.
Mr. Smith, what is your plea?
No contest.
I accept your plea of no contest, find you guilty of this offense, sentence you to 3 days in jail. You will receive credit for the 2 days that you've already served, which is time served. Do you have any questions?
No, ma'am.
All right, counsel, do you have anything you want to add?
Yes, Your Honor. Just briefly, because he's taken a conviction, I'm asking the court to waive any state fines. My client, Mr. Smith, is on Social Security, and he does not have a job. He's out at work with COVID, and for whatever work he could do. And I'm also asking the court to probate any license suspension. Judge, the reason this case was, there's a co-counsel on this case, and Mr. Harold Johnson out of Tarrant County, and I joined in to help him to take this case over. The case has been going on for a while. The blood test came back. I got Brady. I went over it with my client. It's no alcohol. He's had a interlock on for majority of this case. He's just unable to go forward on a trial. He understands the state can still do the loss of normal use of your mental and physical capacity. Given all that, and given how long this case is going, just from an equity standpoint, I'm asking the court to waive those state fines and to probate any license suspension. He did this plea was an agreed plea where he did his conditions up front. He had to borrow the money to take the DWI course and the victim impact course, and those were provided. And I don't believe there's any objection by the prosecutor. She did waive the fine on this case.
When you say probate the suspension, what exactly procedurally are you referring to?
Judge, my understanding is he had an ALR license suspension, which he served out.
Do you know the duration of that license suspension?
It was 1 year.
And so you're asking me to give credit from the date of the ALR suspension towards this new suspension?
If the state because he has a conviction of time served and they resuspend his license, I'm asking the court to probate any sentence or giving time served on the year suspension that he's already done. And we're not exactly sure. I've advised him that I believe that the state will suspend his license and the state is capable of fining those state fees. I know this is a 17 case. I believe it goes retroactively. I'm not sure, but I have advised him when we went over his right to have a trial. We went over all the material. We went over the consequences if he was found guilty, and then we went over the consequences of this plea. And I believe that he may have a license suspension for the jail time served, and I believe he's open to state fines.
Okay, so anytime an individual approaches and asks the court to waive DPS surcharges, the court does require some documentation that the defendant is 125% below the poverty line in terms of income. And so it's my understanding that proof of income regarding receiving disability benefits or food stamps, things of that nature, satisfy the court's inquiry as it pertains to that. So I would like, some documentation to suggest that your client is in fact indigent and that he's below 125% of the federal poverty guidelines. Before I grant that. And that's because I require that information of everyone that asks me for that waiver, if you will.
Right.
And it's in addition to testimony. So I'm asking for that information in documentation.
Okay, I do have a document. I have his checking account that shows he gets $783 a month for a Social Security benefit. It comes from the Treasury. 310XX supplement sec 103020. I can provide it to the court and provide any other benefits.
I would just love to see just his disability designation as far as the fact that he does in fact receive these benefits, because
For what? From MetroCare?
Yeah.
A whole stack of papers. It's at the house.
We can provide that.
It's like 300 or 400 pieces of paper.
No, I don't need 300 or 400 pieces of paper, sir. A lot of times, the Social Security Administration, for example, sort of like a W-2, they'll issue some yearly statement that shows here you're on disability, this is what you received. Or you would have gotten a letter along the way that told you you are eligible to receive Social Security benefits.
Yes,
that's what I'm talking about. So it's usually something equivalent to a W-2 or like a year-end statement that tells us or tells you that you are in fact a beneficiary of this benefit.
Yes, ma'am. So I have to.
I don't need, please don't give Mr. Guscio 300 pages of paper. He doesn't,
No.
That's not necessary. That's not necessary at all.
It's an opinion letter showing you've been granted benefits. And so
exactly.
I can provide that to the court. And as far as the additional testimony, he lives with his mother. She's 78 years old.
79. She's
79 years old. He's the only surviving sibling left, and he's her sole caretaker. But I will, as soon as, if the court will allow, how much time do we have to get the Social Security benefits in?
I mean, I would get it in as soon as possible before the clerks enter the information and it pushes forward to DPS and then he gets charged.
Okay.
I mean, and I can hold off sending the paperwork.
Okay.
But, I don't really like to do that because then it, God forbid I forget, but hopefully I won't. You'll remind me with an email. You send me an email with your attachments.
Yes, ma'am.
And then like Mr. Smith, do you have a tax return?
No, ma'am. I don't have to file taxes because I don't make enough money.
Okay.
I can bring that to the court.
I'm sorry, go ahead.
I can bring whatever paperwork or fax it over, or email it, and then bring it to the courthouse.
Just email it to me. You don't have to do the courthouse at all. Email
Okay.
it to me and reference, obviously, your client's name and cause number in the request, what it's concerning, because I have like 2,300 cases in my court. So
Unbelievable.
draw attention to your client in our conversation, and
Okay.
then we can just do it over email.
Yes, Your Honor.
Okay?
Thank you.
We're off the
What?
record. Oh, actually,